We have in any case provided some brief commentary in our submissions about the various bills that are before the Parliament at the moment, and I am happy to make comments on those. I appeared before this committee last year, but there are a couple of new senators on the committee. So just for the committee's information, I'm a legal fellow at the Institute of Public Affairs. My research covers industrial relations, employment and workplace law, economic regulation and taxation issues. I'm an Australian legal practitioner. Before joining the IPA, I acted for employers in bargaining and industrial relations disputes, but I've also been an employee representative during EBA negotiations. I also just want to provide some additional personal background that doesn't appear in the written submissions. I want to do this because sometimes when I make comments at forums like this, when I appear on these issues and make commentary, particularly on things like penalty rates, I'm often questioned as to whether I understand what it's like to be a low-paid worker. And so I want to answer that in the affirmative by saying, yes, I do understand what it's like to be a low-paid worker. I paid my way through university. My first job that I got at university was as a pizza delivery driver for a large franchise. I won't name the franchise, but it was a large franchise. I was paid around $3.50 per delivery. On a good night, I might hope to earn around $10 an hour. But this was a great opportunity for me because it meant that I could put food on the table. It meant that I could afford groceries. I could fill up the car and I could go and visit my friends and family that lived a few hours away. After 6 months in this position, I moved to the kitchen of a major fast food chain where I was paid around $12 an hour, and there were penalty rates paid on late nights and on weekends, although it was sort of baffling to most of us working there as to why the penalty rates were paid on those shifts but not during the day, because we were university students predominantly, and the times that suited us to work were late nights and weekends, and none of us could get any day shifts during those weekend periods, and yet it was the weekday shifts that we didn't prefer but we didn't get any penalty rates for. I've also worked on the minimum wage as a freight delivery driver. I saw men coming into the warehouse begging to work, and it just wasn't feasible for the employers to be paying over and above the basic skeleton crews that were needed. So I know what it's like. I've seen firsthand the limitations of a highly regulated system. I've seen a highly centralised bargaining system that doesn't take into account individuals' preferences. I've seen a system that distorts business decision-making, and that hurts people that are most in need of work. So I've seen the human cost of that, but I've seen the human flourishing that results in employment opportunities. So while the submission I'm going to make today is based on a strong philosophical basis, it's also a submission arrived through my lived experience. So we believe at the IPA that work is something that we're called to. It's integral to our being. It places us with a community of others. And fundamentally, there's dignity in work. And that's the basis of our research program at the Institute of Public Affairs. In July this year, we published a research paper, Penalising Work, a historical account of penalty rates in Australia. That was authored by myself and my IPA colleague, Gideon Rosner. The contribution of this submission to the committee is to focus the committee's attention on the rationale for mandated, centrally determined penalty rates. Our research shows that penalty rates were introduced in order to deter weekend work. Over time, that justification has shifted to being a compensatory measure, yet the deterrence effects have remained. And so in this regard, I think there's two key points from our submission. The first is that the IPA submits the committee should endorse the Fair Work Commission's conclusion that deterrence is no longer a relevant consideration in the setting of weekend and public holiday penalty rates. The second is if penalty rates exist solely to compensate workers for weekend and public holiday work, which is the compensatory effect that the Fair Work Commission referred to, the question then becomes how should the compensation be set? How should or who should set those rates? Should this be done centrally through an independent commission? Should it be at a workplace level? Should it be an individual level? These are the questions that flow from this submission. In our view, the bills currently before the Parliament seek to make penalty rates even further centralised, more inflexible, and some of those bills introduce or reintroduce a deterrence effect. So the IPA's submission is that the committee should recommend that the bills not proceed in the Senate. And with that, I'm very happy to take your questions.